A preliminary hearing in state court is a probable cause hearing. It's part of the process that you need to get through to get to the second level of a criminal case in state court. So after you've had your arraignment and potentially several pretrials where you're discussing negotiations with the DA's office, your lawyer is, and you can't reach a reasonable resolution, the next step is to go to preliminary hearing. A preliminary hearing is what we call a 115 or a Prop 115 hearing, which means that hearsay is allowed. So cops are allowed to testify about what the witnesses said. So you may not see witnesses other than cops at your preliminary hearing. This is not the time to cross-examine witnesses or put on defenses. It's not the time to testify. This is just a procedural hurdle that you have to get through to get to the next level. So the cops will come in, the DA will ask them questions, your lawyers can ask follow-up cross-examination questions if there are any, just to get the details straight. There will be a transcript of the hearing, and at the end of the testimony you have an opportunity to put on a defense. 99.9% of the time, defense attorneys do not put on any defenses or any witnesses at the preliminary hearing in state court in California. The next thing that happens is we can make arguments. We can argue that the DA did not reach their burden. However, unfortunately, the burden of proof in a preliminary hearing is extremely low. It is a preponderance of the evidence, which means that the judge just has to believe that you probably committed the crime. It is like 1% above 50%, 51%, that they have to believe you probably committed this crime. At which point the judge will hold you to answer or bind you over for trial. And these are just legal terms for taking you to the next step. After the preliminary hearing, the next thing that happens is an arraignment in Superior Court. Now in California, Superior Court is a fiction because there is no longer municipal court, so you're just going to another courtroom in the same building or maybe in another building depending on where you are in which county. In Orange County, you go to a different department, you see that judge, you enter a plea of not guilty, and at that point, you have a right to a trial within 60 days of that arraignment. Then you might get sent to a settlement judge. So sometimes we will put on a preliminary hearing just so we can get to the settlement judge. Also, depending on which judge is in that arraignment court, we might talk to that judge about an offer. We might get something more reasonable than what the DA was offering. So this gives you several opportunities to potentially resolve your case and get the best possible offer if you intend to plead guilty. Now, if you intend to go to trial, of course, the preliminary hearing is the gateway to your trial. After you are arraigned again in Superior Court, you then get sent to a trial court where you will have your trial. The preliminary hearing must be heard within 10 court days, meaning Monday through Friday, or 60 calendar or actual days of your initial arraignment in court. If you give up your right to have the preliminary hearing within 10 court days or 60 calendar days, you then have a right to have your hearing within a reasonable time. Many times we lawyers recommend that our clients waive their right to a preliminary hearing within 10 or 60 days because we need more time to do investigation, to review discovery, to try and negotiate a great outcome for you if you don't plan on going to trial. So most of the time, you're going to your preliminary hearing within a reasonable time. So say it's the day that is set for your preliminary hearing. It's Monday the 5th and you're set for prelim and you show up in court and the judge doesn't have a courtroom for you. So then you come back the next day and the judge may not have a courtroom for you. The day that is set for the preliminary hearing is day 0 of 10, and the court has then 10 days to get you to prelim. However, then there's the reasonable time waiver that also factors into it, so it gets a little bit tricky. But the bottom line is the day that you are set for preliminary hearing may not be the day that you actually start your preliminary hearing. So there may be a lot of showing up and going home and showing up and going home. Sometimes if it's a short prelim, if it's an hour-long prelim, you'll get sent out maybe that afternoon. I recently had a 5-day prelim. We showed up on Thursday. There was nothing. We had to call in on Monday. Luckily, the judge knew us and said, it's okay, you can call. There's also this rainstorm in Southern California. So he understood that we didn't want to drive if we didn't have to. We did show up on Monday, and then the DA ended up agreeing to waive the preliminary hearing. So this is something else you can do, where if you know what the cops are going to say, you have no reason to listen to them, go through the evidence and just upset you and raise your blood pressure and make you angry that you have to sit there with your mouth shut. Then you can waive or give up your right to a preliminary hearing and go right on to the next step. There's paperwork that you have to sign acknowledging that you have a right to this hearing and that you're waiving and giving up that right. Your lawyer will explain the form and the details to you, and then you automatically move on to the next step. And that is preliminary hearings in state court in a nutshell.